gorgeous face. So we want to see that instead of the slide.
All right, we're broadcasting now.
He's going to open it right now.
I don't know where Chaz went. There he is. All right, welcome everybody. I know the room's filling up here. We'll just wait a minute or two as people are logging on, and then we'll get going here. Well, good morning, everybody. Welcome to the Lansing Regional Chamber of Commerce Policy and Regulatory Business Education webinar series. Today's webinar series is focused on the no-fault reform, the no-fault laws that were changed last year and go into effect July 2nd. So we have a little week and a half here. And we're excited to have a great list of panelists with us today. Steve Sinas from the Sinas Dramis Law Firm. Sorry. Gosh, I am so sorry, everybody. Chaz Carrillo from the Chapman Agency, and Scott Norman from Physicians Health Plan, and Grant Hendrickson, who's going to be leading us our PowerPoint presentation, but with the Society for Human Resource Management and Brogan Reed Van Gorder Associates. So as a reminder, this is a webinar format. When you enter the room, you are all on mute. We can't see your video, so don't worry. You may ask questions during the program, but just know at the end of this, we'll have an opportunity if attendees want to ask questions, they may. Just as a reminder for the protocol, you can raise your hand. Please ask a question in the chat box or the Q&A. This program is going to be recorded, so I apologize for the dog barking in advance. And then we'll be sending this recording out after the program to attendees. So if you missed anything, you can go back to that, and it'll be on our YouTube channels, and we'll communicate that out to our membership. But with that being said, again, thank you so much for joining us this morning, and I'll kick it off to Grant and the team here to lead us through this conversation. So thank you and welcome.
All right, well, thank you very much, everyone, for attending this. I know we got a good number of people on this call, so we really appreciate everyone taking time out of their day. I may know some of you through my various professional endeavors. I'll even say that perhaps we've come across each other during the debate over no-fault reform. And I served in an advocacy role for certain groups during that time, and remain an advocate for the preservation of our no-fault system. And full disclosure, I was not in support of these reforms, but I just want to get out there that my objective here today is to be an educator, not an advocate. I do teach the no-fault insurance course at the MSU College of Law, I'd like to think I certainly can fall into the role of an educator and teach people the facts of the law and not get into too much commentary about whether it should be a certain way. So my goal here today is to give you an understanding of what happened with our auto insurance laws last year. And Grant, if you can go ahead and get to the first slide. So in order to understand what happened last year, you need to understand some history, and I'm not going to go too far into this, but just some general background. The Michigan no-fault law, as we all have come to know it, was enacted in 1973. And it was the law that was intended to govern how auto accident injuries are dealt with in terms of all the damages people sustain when they're in an auto accident, how those damages are to be pursued through various forms of insurance, and I'll explain more of that. But before the no-fault law, auto injury claims in Michigan were governed by tort law. And so in 1973, the Michigan no-fault law was enacted, and it replaced tort law as the law that governs auto injury claims. Advance, please. You might say, what's tort law? And in general, the concept is that in tort law, if a person is injured, they can recover all of their damages from the at-fault party. If there's not an at-fault party, if the person's at fault or they just were injured due to some random act that doesn't involve the negligence of another person, then that person would not have a claim. With regard to, excuse me for a second here, the damages, when I say the word damages, when a person's injured, they have medical expenses, they may have income loss because they can no longer work, they may need household services because they can't take care of their house and home due to their injuries, and they also have, or may have, depending on the severity of injury, significant pain and suffering claims where there's a financial claim for compensation due to the fact that their quality of life is so diminished by their injuries. So before 1973, we had tort law as the way we dealt with our auto accidents. Advance, please. The reasoning why we ended up going with the Michigan no-fault insurance law is because under tort law, the medical expenses of injured people were dependent upon findings of fault. So you had to litigate. It was inefficient. Parties would argue that each other's at fault. And in the midst of all that, the ability to pursue payment for your auto claims was delayed, and oftentimes medical providers were not fully paid. So the healthcare economy was being burdened by auto injuries. Next slide. So when you are asking yourself, well, what was the Michigan no-fault law about? It's the idea that people are going to receive certain benefits just because they're in an accident, and that you're not going to make the payment of those benefits dependent upon showing who was at fault. And that's why we call it no fault. And then that tort claim, tort is another word for liability claim or negligence claim. It's all synonymous. That claim against the at-fault driver would be limited to certain damages, and you wouldn't need that claim to recover medical expenses. Advance, please. So that was the general premise of the Michigan no-fault law. And getting to these reforms, what you all should understand is that the reforms did not repeal the original Michigan no-fault law. The reforms greatly modified the law. Certain rights and principles under the original law remain in effect and unchanged as a result of the reforms. On the other hand, certain rights and principles under the original law have been fundamentally changed. And my objective here is to explain what I mean by this going forward here. So you may be asking yourself, this guy is talking about no-fault benefits. What are no-fault benefits? Well, if we can go ahead and just put all the content from this slide on the screen, please, Grant. I'm sorry, go back. Yep. Okay. So first of all, if there's a fatality, there's only one no-fault benefit that's payable to that person, or really their family, their dependents, and it's called survivor's loss. So that's for the economic contributions that the person was bringing into the house or to the dependents. It's capped at 3 years. There's even a statutory max. But the basic point here is that there's this economic loss benefit that dependents can pursue in the event that their parents or whoever was the one caring for them, that they're dependent upon, I should say, we're providing them, and due to the death that they're no longer receiving, they can recover survivor's loss benefits. If you're injured, there are 3 other no-fault benefits. They're called allowable expenses, work loss benefits, and replacement service benefits. The allowable expense benefit is the medical and care benefit. I'm going to explain more about allowable expenses in a second here, but just understand there's this term, allowable expense, and it's the one that's the benefit that covers medical and care for auto injuries. Work loss is compensation for your income loss due to your injuries, and replacement service benefits are for loss of household chores that you can't do for yourself and that you need to pay other people to do. Work loss and replacement services are capped at 3 years. Work loss has this 85% of gross income standard. So that's what you claim, but there's this statutory maximum amount that fluctuates every year. And replacement services are capped at $20 a day. Tying this to the reforms, what's important to understand is that the 2019 reforms only change the amount of coverage available for allowable expense benefits. The other 3 benefits I've just summarized are unaffected by these reforms. So when you ask yourself, what are no-fault benefits? This slide gives you the answer. And what are no-fault benefits under these reforms? The answer is those other 3, then the allowable expense benefits are unaffected by the reforms. And the allowable expense benefit was changed in terms of how much coverage people are required to buy. And I'll explain more of that. Grant, next slide, please. When can a person recover no-fault benefits? I already kind of summarized this general concept, but it's if you're in an accident involving a motor vehicle. You can run the red light, you can run the stop sign, you can be speeding, you can be negligent, and you're still going to recover no-fault benefits. It's regardless of fault, and that's why we call them no-fault benefits. There are limited ways people can be disqualified, and Grant, you can list all those. I'm not going to get into the details of these, but this just gives you a flavor of the limited ways. If you intend your own injuries, if you drive your vehicle directly into a brick wall and you intended to do that, then you're not going to get no-fault benefits. If you own a motor vehicle and you're injured while using that uninsured, and it's uninsured and you're injured while using that uninsured motor vehicle, you will be disqualified. If you knowingly use a stolen vehicle, you will be disqualified. And importantly, under the reforms, this was not the case prior to the reforms, but all out-of-state residents, anybody who can't say that they're a resident of Michigan, is disqualified from no-fault benefits unless they fit in the very limited circumstance of being an out-of-state resident who owns and registers and insures a vehicle here in Michigan. So I could take some questions at the end perhaps about what this really means for out-of-state residents, but just understand that there is this new disqualification. Otherwise, these standards under the reforms remain the law going forward. Next slide, please. To give you an idea about why the reform debate was a very contentious debate where a lot of groups and people came out against them, and also why there was so much push to reform the laws in the way that they are ultimately reformed, it has to do with this sentence that defines allowable expenses. And allowable expenses, I gave you the term, but the definition is any charge for any product, service, or accommodation that's reasonably necessary for an injured person's care, recovery, or rehabilitation. So the other thing about this sentence is that under the original law, it's not followed by any monetary cap, any time limit. This is what makes this the lifetime unlimited benefit as we became to know it here in Michigan. Now, the thing about this sentence is that the definition remains. It's just that people can buy policies, and if they're in accidents under certain circumstances, they will be limited in terms of how much money they can claim for allowable expense benefits. It'll be a monetary cap on their coverage. And Chaz is going to cover that in more detail in terms of all the options as well. But the idea before the reforms is that everybody had to buy no-fault insurance that covered all the benefits I'm talking about. And with respect to allowable expenses, they couldn't buy a policy that limited those to a certain dollar value. It was a right to claim those benefits for anything that's reasonably necessary, and that right was a lifetime right and unlimited by a monetary cap. Grant, next slide, please. To further illustrate this, and Grant, you can just list them all out. This concept of an allowable expense benefit being something that is reasonably necessary for the injured person's care, recovery, or rehabilitation has resulted in the following realities in terms of what benefits or what services and expenses constitute an allowable expense benefit. It includes hospitalizations, obviously, surgeries, inpatient care needed for the auto injuries. It includes nursing and attendant care at home, rehabilitative therapies, medical transportation, medical mileage, housing and handicap accessible accommodations, case management services, guardian expenses. You get the idea. And I can tell you from representing catastrophically injured people, all these forms of expenses and services and accommodations can mean a great deal to their ability to get by in life following a catastrophic injury. So this is what makes the no-fault system so important to these people. It's what makes the no-fault system so unique, because there aren't any other states that have such a comprehensive benefit. And it was really what was at issue in the fight over these reforms in terms of whether people should be able to limit it and not have the lifetime right to this type of coverage. Next slide. The other thing you all should know in terms of this being an informational piece here for you all to know about in terms of your own professional endeavors and just as consumers is that prior to the reforms, there was a choice we all could make in buying no-fault insurance coverage. And we could choose to either coordinate our coverage or uncoordinate it. And just to give you a quick explanation of what that means, if you buy coordinated coverage, that means that you are elevating your health insurer, your private health insurer, to pay before auto has to pay. Auto would only have to pay in that situation of where you bought the coordinated no-fault policy for treatment and care that's not covered by health insurance. So you have to satisfy the rules and regulations under your health insurance policy, pursue that coverage, and then what's not covered would go to your no-fault carrier. The exchange that you're getting for that should have been that your premium was significantly reduced because of that huge cost shift away from the no-fault insurer onto your health insurer. Not to get too much into the history here, but there are some indications that perhaps that discount wasn't really what it should have been for consumers. Insurance companies would argue with me on that. But the point is you're supposed to get a premium discount, and there is a big cost shift that allows your auto insurance company to not have to pay for your frontline medical care. And that was always part of the system. The other thing you should know about this concept is that it remains part of the system, meaning that you, with all the options that Chaz is going to present, they can be coordinated if the insurer chooses to do so. In other words, it's optional for insurers to coordinate their policies. It's something that you all should just be aware of in terms of what you're being sold. If you don't know the answer to the question of whether you have coordinated no-fault or uncoordinated no-fault, then I would submit to you, frankly, that means that you don't really know what coverage you have, because it's such a big difference. You should also note that you cannot coordinate if you have Medicaid or Medicare. That is the result of those being government-run health insurance programs, and they have regulations within them that says that they cannot be elevated to be primary. So if you are one of those people and you try to coordinate to save a buck, your agent is going to tell you that you're not able to do that. Next slide, Grant. So just to give you some more information about how no-fault works, and this rule remains in effect following the reforms, if you are in an accident, the general rule is that you turn to your own insurance policy if you have your own, or the policy of your spouse or any resident relative that may be living with you. So if you're related to a person and they're living with you, you turn to their policy if you don't have one. So the general rule is you go to your household. There are exceptions to that general rule, and I'll just quickly identify them. If you're on a motorcycle and you're hit by a car, you go to the policy for that car. If you're driving an employer-owned vehicle, you go to the policy that the employer issued on that vehicle, and that's true for you, your spouse, and your children. So if you take your company car home and go to dinner and you're all in a wreck, you're going to claim no-fault benefits not through your own insurer under the general rule, but through your employer employer's policy. And there's also certain situations where vehicles for hire, you turn to their policy and not your own. I'm not trying to give you technical details here. You'll see how this comes together as I try to piece together what this all means for reforms going forward. No fault reform did not change these general rules. That's one basic point here. Next slide, Grant. So here's the deal. I'm trying to find the clearest path to explaining to you all that with regard to these reforms, they have a huge impact on the medical coverage that's going to be there for many injured people in the future. And whether you're in the medical world, legal world, insurance world, or just a consumer, everyone just needs to understand that these reforms have certainly a huge impact on the amount of coverage that's going to be available to people. So here are a couple of realities. There are 4 of them here, 2 on this slide and 2 on the next. This first reality on the left says, with limited exceptions, a person's no-fault policy covers the named insureds, their spouses, and resident relatives. All these people will be subject to the cap/limitations on the policy in that household. So when Chaz explains to you all the various ways people can cap their policy, understand that that's a choice not just for that person, but for anybody who lives with that person, their children, their spouse. Everybody will be subject to that cap. So in other words, if the person chooses to cap, all those people, if they're ever injured, will never have the lifetime right to the medical coverage I was just summarizing. The corollary point there is that with limited exceptions, if the household, if there's not a lifetime no-fault policy in the household, then no lifetime coverage will be available to people injured in Michigan auto crashes. Meaning if you're not in a household with a lifetime policy, you're not going to get lifetime. So just like that, these laws took away the right to lifetime coverage for potentially, the vast majority of people injured in crashes, unless they choose to buy the lifetime coverage. Next slide, Grant. The other thing about the system we had was that it was supposed to be a system that covered the medical care needs for people injured in auto accidents and not have it go on to the government. So there were mechanisms in place, rules in place, where people who were not covered by a policy, didn't have a household with an insurance policy, but were injured in an auto accident, where they were able to claim no-fault benefits, and sometimes from the policies on the other vehicles involved, even though they were a stranger to those policies. Long story short, the reforms took out those rules and basically has this rule. If you don't have a policy in your household, as long as you're not disqualified from benefits along the lines that I just summarized, you'd be entitled to no-fault benefits, and you would claim them through this entity called the assigned claims plan. Don't worry about exactly what that is. It's a way of getting an insurer to be assigned your claim who didn't really insure you. It's a random process. It's effectively what it is. But the real point is that all these people would go to the assigned claims plan, and the law says that they are now capped at $250,000 of medical coverage. So it's another area where people will not have the lifetime right. The other thing about the reality of coverage going forward is that, as I was touching on with the general rule, you turn to your own insurance company, but there are exceptions. Here's an example for motorcyclists. As I said, if the motorcyclist is hit by a car, the rule is they turn to the policy of the motor vehicle involved, not their own auto policy. But if the motorcyclist buys lifetime going forward and is hit by a car with a limited no-fault policy, that motorcyclist is going to be subject to the limits of that policy and won't be able to benefit from their decision to buy lifetime no fault. That is the same with the employer-owned vehicle situation. The rule says you turn to the employer's insurance policy. If the employer decides to limit their policy and the family gets in the car, they go to dinner and they're all hurt, even if they had lifetime in the home, the reforms did not factor in the fact that they would not be able to benefit from that lifetime policy, and they would be subject to the caps chosen by the employer when the employer bought the insurance. Next slide. So this is my take, and Chaz is going to give you his take. I never really knew Chaz before we decided to work on this presentation, and we have our own perspectives for our own reasons. It's my understanding that Chaz basically agrees with this take, and he'll confirm that for you. But as an attorney representing injured people, and based on what I know about how health insurance works in America and what the no-fault system can do for people, the safest option for people going forward, amidst all the options that they now are allowed to choose from, the safest one is for people to buy unlimited, uncoordinated, non-managed care, no-fault medical expense coverage. So if you had lifetime, what I'm really saying is you keep your lifetime, Don't coordinate. Don't make yourself have to serve two different masters of the health insurer than the auto insurer. Straight path to no fault carrier if you're ever seriously injured, and have an unlimited amount of coverage so that you'll have all your needs, your reasonable needs covered if you were ever catastrophically injured in a crash. Next slide, please. So you might be thinking, hey, at the start of this, you started talking about tort law and this claim against the at-fault driver. Well, I'm going to quickly explain how that fits in the picture. What I just covered were no-fault benefits. Those benefits I summarized and the standards that I just went through were all standards that apply to those benefits. Now, if you were injured as a result of the negligence of another driver, there are damages you can pursue against that at-fault driver. You can pursue pain and suffering damages, but you can't pursue these. And by the way, non-economic loss, that's another word for pain and suffering. You can't pursue these damages if your injury is not sufficiently serious. So if you're have sustained minor injuries, Michigan law says you can't pursue pain and suffering from the driver that caused you to sustain those minor injuries. You either have to be killed in the crash, sustain a permanent serious disfigurement, or have a serious impairment of body function. There are definitions for those terms that I just threw out there. Just understand it basically means you have to be pretty significantly injured to have a right to these benefits. Moreover, you can only recover pain and suffering benefits from the at-fault driver if the other driver is more than, or I should say, if you are 50% or less at fault. So if you are more than 50% at fault, you cannot recover these benefits. You may remember I said work loss is covered at 3 years. That remains the case. If you have work loss beyond 3 years, you can pursue that excess economic loss from the at-fault driver. Under the original law, because everyone was covered through lifetime medical, these were the damages that you could recover against the at-fault driver, and you could not recover medical expenses. Next slide. So I just kind of touched on this. Here on the left side, you see under the original law, because injured people had lifetime no-fault medical coverage, at-fault drivers cannot be sued for medical expenses. That was the reality, whether you knew it or not. You and the vehicles you own, and the vehicles that, if you're an employer, your employees drive around, we're driving around under the idea that if they cause an injury, they could, you as the vehicle owner, or you as the driver, or you as the business who employed the person who caused the crash, could be sued for pain and suffering, excess economic loss, but could not be sued for medical expenses. The reality under the reforms is that injured people are now able to limit their medical expense coverage. And what the reforms had in it is also the right for these people who limit or opt out from their medical expense coverage to sue the at-fault driver for the injured person's past, present, and future uncovered medical expenses. Let me tell you, if you're catastrophically injured, it's not hard to get any life care planner to look at your needs and put together the information of the cost of medical care in America and say that you need multiple millions of dollars of care. And in fact, we know that's the case through how we cover people through our no-fault system. If anything, the amount of money going out to the no-fault system to catastrophically injured people was one of the reasons why the insurance companies say that they had to raise our rates so much. So we know that medical expenses can be exorbitant for those who are catastrophically injured. And the point here is that if you happen to make a mistake and injure somebody, you now can be sued for those exorbitant medical costs, all of them. Next slide. The other thing about this rule, and not to get too heady and academic on you, but you should understand the extent of it, this slide talks about comparative negligence. Comparative negligence is a legal doctrine. Under this doctrine, what it says is that a driver can be held liable for medical expenses in proportion to any percentage of their fault that is greater than 0. So here's an example. Say Bob is 90% at fault, but Wanda is 10%. I'll give you a hypothetical that might be consistent with that. Bob blew the stop sign, but Wanda was driving 10 miles over the speed limit. Perhaps the jury says, well, Wanda was somewhat at fault, but Bob really, was the cause. So we're going to say Bob is 90%, Wanda's 10. Under comparative negligence, if Bob is catastrophically injured and has a life care plan of $5 million, he can sue Wanda for 10% of that $5 million. And that's part of the new rules. Next slide, please. So here's my, this is my segue over to turn it over to Chaz. The bottom line regarding these new rules regarding liability insurance is that the reforms allow people to sue each other for much more money than they were ever able to sue before. So this is a huge exposure to everybody. If you're somebody who has any assets or is collectible at all, wants to prevent yourself from having to avoid a judgment against you, you need to think about these new realities. And the point of action would be, from my standpoint, to increase your liability insurance. And those who don't know, you should look at your insurance declaration page and try to understand it, but you'll see that there are line items of coverage. Chaz will be talking more about them. You have a line item for no fault. If you buy a limited no fault policy, you get a certain reduction for what you've been charged for that. But you also have a line item for liability insurance. And I'm saying that you should buy more liability insurance than you had before. As I touched on before, if you own a vehicle and you lend it to your child and they cause a crash, or a friend, anybody's using your vehicle with your permission and they hurt somebody, you have derivative liability as a vehicle owner under Michigan law. Also, if an employee is using your vehicle in the scope of their employment, then you have derivative liability for their acts. So people and businesses now all need to buy as much liability insurance as possible. I hope this gives you a good idea about the legal principles that really are at the core of these reforms. Oh yeah, I'm sorry, I don't have my own slideshow in front of me, so Grant's reminded me that there are a couple other points here. You should know, if you really want to understand the full extent of these reforms, that what I went over were the major changes in terms of the legal principles, and Chaz is going to give you the specific options. But there are other major ways in which the no-fault law was changed. There's a drastically reduced medical provider fee schedule that is going to go into effect on July 2021. Every medical provider I've talked to, especially in the post-acute side, is especially concerned about what this means for their business. There's a real concern that this could have a big effect on many medical providers throughout Michigan, and in a negative way. There's a limitation on family provided attendant care. That's the right for family members to get paid. There is issues with families perhaps claiming care when they weren't providing care, which fueled the fire to have reforms here. Now all families are capped at 56 hours a week. So if a family wants to care for a catastrophically injured family member, they no longer have the right to be paid for all their hours. They're capped at 56 hours. That includes family members, friends, any person the injured person knew would be subject to this cap. That goes into effect on 2021. There's also utilization review, which is basically government insurer controlled regulations over the payment of allowable expense benefits. The Department of Insurance and Financial Services is drafting those rules. They've been taking public comments. It's my understanding that the official rules will be issued in the very near future, and that will have a whole new way, or that will create a whole new way in which we have to pursue payment of medical expense benefits under the no-fault system. There's also a fraud authority to investigate and prosecute consumer fraud. It's my understanding that's effective now, and they're getting it going. There's not much in the statute regarding the fraud authority also applying to insurance companies and whatever bad acts they may have. I certainly don't believe that all insurance companies are bad. I know many insurance companies that do the right thing, but I do see insurance companies do the wrong thing. And when I heard about the fraud authority being necessary to make sure everyone's playing fair, I was hopeful that was going to be a two-way street. And as far as I can see, it's not so much a two-way street. It's focused on the consumer and medical fraud out there, which obviously needs to be eradicated, but we need to make sure everything is done the fair way. I'm going to turn over to Chaz. One more comment. The rules that I was just summarizing are intended to people who are already in the system. And that flies into a constitutional argument about whether the legislature was infringing on the contract rights of these people who are already injured and had their benefits under the old law. And actually my firm is in a constitutional challenge over that issue and a few others regarding this law. But I'll turn it over to Chaz, and thank you very much for the time.
Thanks, Steve. A lot of information. Everybody take a deep breath, maybe stand up, stretch a little bit, move around. It's gonna be okay. We have some products to help you understand this, and I'm gonna go over that as far as your options right now. As the slide shows, there's a couple different options as far as limits or medical caps that you can choose with this new law: 50, 250, 500, and of course, it's listed there as a lifetime cap, but I would more accurately say that all of them are lifetime, but an unlimited medical expense would be the option that you can choose to keep. The important thing that Steve mentioned near the close there was that at-fault drivers can now be held liable for injured persons' uncovered medical expenses. And so a phrase that I've been using to describe that is that it somewhat encourages bad behavior, because it could encourage you to get a smaller amount and then, of course, sue for those extra medical expenses that aren't covered because you decided to choose the smaller amount to save on the premium that you're paying. So I'm going to go over that, what these options look like, how you qualify for them, attendant medical care rider, and the managed care concept. So if you want to skip to the next one. The basic rules regarding capped PIP choices. Policies are pretty varietal. And again, I kind of went over the general rule there, but I wanted to, before we make those considerations, I want to mention a few things that that Steve alluded to or directly addressed, which is that you need to make sure that you are that you're aware of how that's going to affect young drivers in your home, how that might affect college students, especially college students that may have a residency or live away from you but maybe return, that may or may not be on their own auto policies. For business owners, the difference between drivers on their personal and business policy, if they have their own personal auto or not, and consider what the differences are now and how that might need to change for the future. And then out-of-state non-resident drivers visiting, using your vehicles. The best example of this is going to be actually be me to look at, or me to point out maybe a business that hires a lot of college students, maybe a business on campus that may have drivers that drive things and deliver food or other items to people. Those non-resident drivers now have limited coverage, not only for their medical expenses if they're not en route to work, but also for the property damage they cause, which actually just came down yesterday from MAIA, a notice of a property limitation now that was enacted by this rule. I won't go into too much detail there, but just to say again, there is a difference now between non-resident property damage and resident property damage for business owners, for those people that they employ. And then just the medical coverage differences, which Scott and Grant are going to talk about how things are adapting on their side. So we can go to the next slide. Cap, this medical cap applies to your choice as a definition for medical rehab expenses. They do not apply to work loss. So work loss, replacement services, survivor benefits, those have not changed. They're the same remaining law that we had before. We can go to the next slide. The basic rules regarding these cap choices are that they apply to each individual claiming benefits under the policy. So if multiple family members get hurt, each gets medical expense to that cap amount. Next slide. The basic rules here on the higher cap applies. If different level of coverage in the house, then we switch to the higher policy. So if the parent has 50 medical coverage, another parent has 250, assuming they have each of their own policies, the higher amount, the 250, would apply to the child in the house, not the lower amount of 50. Next slide. In order to opt into these choices, you have to fit certain demographics, certain criteria that DIFS has explained, and you have to sign an additional form saying that you understand those differences. Next slide. As far as the rate reduction, the rate reduction only applies to the cost of PIP insurance, and the reforms do not guarantee that the total cost of a person's policy will go down. And this is extremely important because in certain areas of the state, I've already seen several situations where that policy premium has actually gone up, even though this medical option has gone down. And so there are a lot of moving parts to that, but just to know that, again, the rate reduction specifically applies to PIP, and also the other reduction consideration there is what the MCCA fee has been reduced to now, where it was used to be scheduled to 20 is now lowered to 100 if you keep the unlimited medical expense. Next slide. The rate reduction is not based on percentage reduction of the actual PIP, and this is just making sure people understand that if you cut your unlimited to 500, you know, that isn't going to change your policy by 50%. But the rate reduction is based on the average reduction per vehicle from the premium rates for PIP insurance coverages that were in effect May 1st, 2019. The statute does not provide any further guidance on how the reduction should be calculated. These premium reductions are guaranteed through July 1st, 2028. Next slide. I kind of highlighted this as far as the different scenarios for premium that are calculated on the 6-month policy. That the affected premium out of this whole policy are those two line items: that personal injury protection and MCCA fee. There are some other fees that the state uses, and again, those fees are just changing. Specifically, the MCCA is lowering, but in light of this law change, actually, those other fees are going to get used more. So it is likely that those will continue to increase based on their overutilization now. Next slide. So people can coordinate capped PIP choices. Again, the coordination didn't change based on this law. So decide to coordinate or uncoordinate, the same rules apply as they would have before. Next slide. For the $50,000 cap, this is offered only to the person who is covered under Medicaid and the person's spouse, resident relatives are on Medicaid or have other health insurance or have PIP coverage through a different policy. So that is optional. You have to be on Medicaid to choose that $50,000 cap choice. You have to sign an additional form explaining what that choice is, and that form has been approved by DIFS and is consistent with each carrier. Next slide. For the 250 option, those eligible for this option, it's available to any person without limitation. There is an additional form to sign from DIFS that they've approved, that they completely understand the difference in coverages here. This, because of the medical expense tort rights, they will be able to sue an at-fault driver for any medical expense in excess of this cap now. Next slide. For the 500 cap, this again is available to anyone without limitation. And again, they also have the right to sue now anyone if their medical expenses are in excess of this cap. Next slide. So as far as the unlimited lifetime medical expense, this option is available to any person again without limitation. This choice applies to the person's spouse, and any resident relatives. So regardless of what they chose, if they have a different policy, it would actually automatically go to the highest policy. Again, the similar example I gave you for the 2-parent, 1-student household. So if other people had a limit, but they're in the same household, it would go to the unlimited option, and that they would be covered by the unlimited lifetime medical expense. In most situations, there's no TORT right to recover medical expenses for people who buy this option. Because they're being fully covered. As far as the attendant care rider, I'm off track for what my slides were, so I'm just trying to find where that is. The attendant care rider is an option. If you choose a limit, you can attach this rider to cover attendant care, which usually is extremely limited or not accessible through your primary health policy. The benefit here that we've seen so far is that this rider is almost non-existent in cost. We're seeing a difference of $2 to $10 in premium for the year by having this additional rider. Now, while I would not contend to limit your costs probably under any or most conditions, I would say if you did, it would make absolute sense to have this rider on that policy. Next slide. So the 250 excluder opt-out, that's if a person selects the 250 PIP level of coverage, if that person, his or her spouse, all resident relatives have other health insurance an accident coverage that extends to auto-related injuries, then the insurer must offer an exclusion that would at least exclude all allowable expense benefits payable under that section of the law and may very well apply to all PIP benefits. And the reason of this is basically what I went over earlier. Now that we have the availability to access the higher levels, we want to specifically exclude drivers that are potentially not insured or don't have the proper coverage in place, because we want to make sure that they do have the proper coverage in place. Otherwise, you will be paying for it on your policy. That insurer assumes that responsibility. Next slide. And this kind of explains what if someone loses their health insurance, so they're an excluder is injured and then they lose their health insurance. Right now, we can only say, we haven't seen this enacted obviously since it's July 2nd, but it appears that the excluder would not be entitled to any no-fault PIP benefits and would either need to purchase other health insurance or go on Medicaid or Medicare if they don't notify within 30 days of that loss to the medical insurance and have that medical option in their auto policy changed. This is crazy. It would be my non-emotional version of that, of saying that. And so we want to make sure that, again, if somebody does have that exclusion, they completely understand signing that form, but also understanding the limitations that they've given themselves. Next slide. This Medicare opt-out, we can make this available. Obviously, we're showing it here. But this Medicare opt-out, I think, is a really good example of what Medicare and what auto no-fault gives you, and as far as the differences, kind of a summation. Obviously, there's a lot more details in this, but a summation of what those limitations are if you choose to opt out if you have Medicare. Next slide. This managed care option, we just call it a concept because we haven't seen, I personally haven't seen any carrier that has offered this yet, but the concept is that managed care options at this time, that they would come out when the policy is issued. This option would include, but not limit to, the monitoring of the injured person, and use a preferred provider program or other network or similar option. And so, again, the section law language is there, but we haven't seen this actually come to fruition yet. So more on that when it exists in real life. Next slide. The bottom line regarding no-fault PIP choice buying decisions, the safest option, again, from my agent perspective, is for people buying limited, uncoordinated, non-managed care, no-fault medical expense coverage. That'll make sure that your family, your business is properly protected. You choose who you go through, what that looks like. You don't have to bop around between two different groups. And if catastrophically injured, you're going to make sure that everyone is taken care of as well as possible. And that is in itself one of the cheapest health insurance options you can purchase in your life. That additional premium for not having coverage versus having coverage that's not limited is extremely affordable. Next slide. As far as liability, this further exacerbates the need for liability coverage because it's going to involve probably a lot more, most likely a lot more activity based on the information that we've shared so far. And so to get as much liability coverage as possible, making sure that your assets covered and future income is protected is really important, especially as a business owner. Next slide. As far as buying under uninsured coverage, this is an optional coverage. It is not required under the new or old policy. And this actually helps protect you from a settlement or judgment in your favor. And so this would be more important because of the law differences. And I would encourage you to have the same amount of under uninsured as liability coverage to protect your own family. Next slide. Other risk factors to consider is is obviously making sure your liability risks for your auto use, but under your workers' compensation package is properly aligned and adequate to protect your assets and future income. That you reinforce the importance, especially as a business owner or someone with assets, that your personal policies are in order to protect your business and your assets, not just your business policies. That you utilize umbrellas for additional protection for liability and under uninsured coverage for your business and for personal umbrella. And then for the property coverage from out-of-state drivers is limited or at least understood well moving forward. Next slide. So the best way to deal with this, obviously it's a complicated issue, is to have the right people on your side. And so just making sure that you contact your business auto insurance agent, your lawyer, to make sure all considerations are made properly, that you, your family, everything is going to be protected as you understand it, as you expect those things to work. And that you make sure to contact your health insurance and your health insurance agent, make sure that they're aware of any changes and that everything works really well together to properly protect your business and family. So that's all I got. I know we're going to go over to Scott.
Hey Scott, right before you start, I know we're kind of getting close on the hour here, but we're going to continue to move forward. And again, we are recording this so we can send it out to folks if they need to jump off. But really appreciate this information. I mean, there's a lot here, but I just wanted to make sure, and I appreciate Stephen answering folks in the chat box. So if you do have questions, please put those in the chat box. With that, Scott, I'll let you get going.
Well, I'll be brief, and I appreciate it. And it was really good information. I was actually taking notes and listening intently to learn more because it is complex. I'll be really brief about what PHP is doing as a health plan and some of the impacts. And you can go to the next slide, Grant, and I'll quickly go through these. So at PHP, we made the decision to continue to pay for all of our fully insured employer group, individual, and Medicare plans as primary. And that's consistent with what we've done in the past. I will make a point, though, the key term there is fully insured. That means that those employers that are self-funded, which typically large employers will self-fund their health plan, they still have the choice as to whether or not they will pay as primary, secondary, or exclude auto. So it's important there, if that employer does choose to exclude or pay secondary, they need to notify their employee. But it's important to make sure you do your homework. If you're not sure, contact your employer, contact your agent, because if that employer chooses to not pay as primary, then the ability to opt out on PIP goes away. So you have to make sure you know what you're doing. This is kind of that education piece, and you all touched on that often in the earlier comments. The other point I would jump to the bottom is, even though we're paying as primary, the health plan coverage, as you all have mentioned, is not as broad. So that doesn't mean that we're going to cover all the things that PIP did. What I say is we kind of put you back together. That's our job at the health plan. But the broad coverage of PIP is not what we would typically cover. So again, really important to understand what you're buying. For employers, the one thing I would say is there are always, I don't want to call it maybe a law of unintended consequences with these things. I do think ultimately that this will put some pressure on employer-based premiums because we do think we'll see a slight increase in claims. But more importantly, when you think of what the impacts of some of this law will do is, if you think of Sparrow as a local community-based hospital, Sparrow is the only level 1 trauma center in mid-Michigan. The impact of this is probably a negative impact of about $17 to $20 million a year in revenue to Sparrow. And all hospitals across Michigan are going to feel an impact from this. And what will hospitals, we want a level 1 trauma center here in our community. I think everybody would agree on that. What's important though is, if you're a hospital looking at revenue issues, you can't increase your rates for Medicare. You can't increase your rates for Medicaid. The only place you can look is commercial rates. And what that ultimately will do is put pressure on those, probably resulting in higher premiums down the road for employers. So it's one of those things to consider. It doesn't get talked about much, but as an employer, you just have to understand that, sometimes we're shifting costs, and that's kind of what this is a bit of a cost shift in some regard that will have a long-term impact. The other thing I would point to is the qualified coverage piece. Most of our plans are qualified, but your plan has to be qualified, and that's a $6,000 deductible limit. Not all of our plans are. So if you have a question, you can contact your agent, you can contact our customer service, and give us a call or give your agent a call. I always say contact your agent. They're really knowledgeable, whether it's your health agent, whether it's your P&C agent. But for most people, as you all have pointed out, this is pretty complex, and there are options. But those options sometimes may seem more appealing in the beginning until you start to unpack and unravel things. And I would always caution people to do your homework, know what you're buying, and make sure you're making the best decision for you as an individual. And that's probably the best advice I can give somebody as they're trying to navigate this over the next months to years. And I'm going to transition to Grant, who will kind of pick up a little bit from a benefits consultant point of view, what the impact is that they're feeling.
Thanks, Scott. And I'm going to be very brief. I don't have a slide because we've already been through 47 slides today, but really amazing information from Mr. Sinas Carrillo and Scott Norman. Our perspective from a benefits consultancy is that when you're looking at your health insurance plans at your organizations, fully insured has always been primary, and it is going forward with all insurance carriers in the state of Michigan. And so if you're a large employer and you're self-funded, you do have some options to consider. And so what kind of exposure do you want to present to your employees? And also from a fully insured perspective, how are you going to try to help educate your employees about what's truly in their best interest? The unlimited PIP protection is by far the most affordable health insurance you can ever buy anywhere. And me being a health insurance consultant, without a doubt, I'm going to pay the extra. I think it's about $100 every 6 months to maintain unlimited PIP coverage. It's kind of a no-brainer. And, you know, Scott referenced it just, you know, a minute ago about health insurance has limitations to what they're going to cover. The example I like to use is, you know, you look at rehab benefits. Typically, rehab therapy visits ranges anywhere from 12 to 24 to 30 visits. Maybe if you've got a really robust plan, maybe you have 60 visits per calendar year per person. If you're in a terrible accident and you need care every single day of your life, or rehab therapy, which we've got friends and we've got clients that need rehab therapy every day of their life. If your health plan only has 30 visits covered, and now you're going to be on the hook for everything after that, and you choose a lower, you know, PIP coverage level, you're just going to be opening yourself up to a lot of frustrations financially. So by far, best value, take the unlimited PIP. And this is a position that I think most agents across the state of Michigan are taking as well. So with that, I think I'll kick it back to Mr. Japinga for a brief Q&A here before the hour's up. So with that, thanks for tuning in, everybody.
Yeah, thank you to all of our panelists. That was well done, and 2 minutes to spare. But right now, yeah, go ahead, Steve.
I was just typing a response, and somehow I deleted half of my response. So I'm not trying to scramble and type it again on this Q&A box here. But somebody asked, if an employer opts out of no fault and an employee gets in an accident, can the employee then sue the employer for excess medical expenses? What I was trying to explain is it's actually the opposite. If the employee is driving in the course of their employment and causes a crash and happens to injure somebody who has decided to opt out, that's when the employer could be sued for all the medical expenses, because their employee happened to cause a crash with somebody who opted out, and those who opt out can sue for the first dollar of their medical expenses, beginning with the ambulance bill. So if your employee is in a crash and you've opted out, the implication of that might be that your employee then runs into your opt-out on the policy and can't access benefits. So in that sense, the decision to opt out on your no-fault coverage as an employer could harm your employees if they wanted to access their no-fault benefits through your policy or were supposed to. But the flip side is the concern on your liability insurance that your employee could randomly be in a crash with somebody who's opted out, and then you get hit for all medical expenses from the first dollar to the end of that person's life.
Thank you, Steve. Again, attendees, if you have any questions, please feel free to ask those in the chat box or Q&A.
I just have one thing to add on that, if you don't
Yes.
mind. So just to further the point, that also, and correct me if I'm wrong, Stephen, but that also indicates, again, the percentage of liability comes into play with those medical expenses also. So it's
Yes.
not 100% responsible. That's even 10 to 20% responsible for those medical bills are now going to be pushed to that employer in the scenario that he gave. So that's an important distinction, because that means that there is no excuse me, that really, again, that exposure, that just kind of highlights how the exposure to employers has grown quite a bit because of the law change.
And when you have a crash, you know, whether the person who is more at fault or, you know, not, whoever, you know, happens to be more at fault, they can be seriously injured too. And because that pure comparative negligence where I'm talking about, the fight over fault is going to be a great one. There's going to be all kinds of reasons for people to say, well, hey, I might have been more at fault, but you were looking at the, you know, at your phone, or you could have seen me, you know, and there's ways you were at fault too. And that just is going to be a mess to sort out in lots of litigation.
Thank you both. So questions are coming in from the chat. What other states have no-fault insurance?
Well, that was a big question that came up during these debates. The reality is that no other state had the type of no-fault coverage Michigan had, which was that unlimited right, meaning any other state that had no-fault systems, they had these caps. And one thing that I don't think anybody has any real reliable research on, it's all anecdotal, but I hear people who are on the pro-reform side saying, well, hey, cap no-fault works fine in other states. I then talk to people in those states and they tell me that really the reality is that catastrophically injured people don't get what they need. They get forgotten about, and they don't have the type of resources they have here in Michigan. So to answer the question, there are other states that have no-fault systems. They all have caps, and whether those cap systems really work for injured people is something that was a big debate. And from my standpoint, and what I know about health insurance in America, when I talk to lawyers who actually represent catastrophically injured people in those states, it's a tough road to toe for them.
Thank you, Stephen. Next question. What about medical plans with high deductibles? Can the injured enrollee sue the negligent driver or sue their insurance company or carrier?
So
from Carrie.
Yeah, I see that. I'm trying, okay, with medical plans with high deductibles. I guess the way to look at that situation is one where a person is injured and they have to pay the high deductible under their health insurance. And the question is, well, can they pursue reimbursement of that deductible? If they have coordinated no fault, they would be required to go to health insurance first. But then as part of the liability of the no fault carrier, people can often claim their deductible from their no fault insurance. However, if you opt out, if you're one of those people that have the health insurance that covers auto to some extent, then you can opt out of no fault, as Chaz explained. And in that situation, if you had to pay the high deductible, you would not have the right to turn to no fault and get paid for that, which I think is one of the big kind of underrated drawbacks of the exclusion. It's crafted around the idea that everyone who gets it has health insurance that covers auto, but that health insurance leaves people with deductibles, copays, and other uncovered expenses. So if you opt out, you don't have any coverage for no fault for those types of additional expenses.
Thank you.
I see
Next
one here.
question.
Yeah, okay.
Yeah,
go ahead.
I'll just say the question for the recording or whatever, but if my health insurance will cover my auto injuries and put me back together, why should I buy unlimited PIP or any PIP, especially when I can sue the at-fault party for all future unlimited allowable economic damages?
Well, I don't want to be the only one talking. I certainly have a response for this. If anyone else wants to take the first stab at it, go ahead.
Well, my initial thought is, what if you're the person that was at fault, right? So you caused the accident. Who are you? You don't have anyone to sue, right? Except yourself. And then, Steve, why don't you take a more legal approach?
I'll let you answer that, Steve.
Yeah, so that's a very valid point. I mean, it's a very basic reason why you'd want to have the unlimited coverage. And it gets back to some other points that have been raised throughout the call, especially by Scott. When it comes down to it, health insurance, this idea does it cover your auto injuries? Well, yeah, it covers them to some extent, but is it going to cover the long-term care needs you or your family is going to need when they go back home? The long-term rehabilitative therapies. I mean, people don't think along these lines because they don't think it's going to be them. I can tell you that every single client I have had never thought it was going to be them. And then all of a sudden their family has to adapt. And they quickly realize that health insurance covers a lot, but not everything. And if you're not working and you're, have the financial burdens of just being an injured person, these expenses can add up, and the limitations on your therapies can really be a big issue. One thing I'll throw out there, and I certainly hope that our new insurance commissioner, who's obviously working very hard to get everything squared away with these reforms, there's so much to consider. I hope that there's more scrutiny, that if we coordinate and if we're these people that have health insurance that covers auto and we choose to elevate health insurance first, that we get that better reduction, that better discount on our no-fault premiums because of the fact that health insurance is paying for so much. And I have a pretty good basis to say that maybe for many years, that discount wasn't what it was supposed to be for consumers. So I certainly think that there's a reason to get it, a reason to buy unlimited no fault even with the health insurance. But you should also, if you're coordinating to have the health insurance pay first, get a pretty good price break on your premium. And it's going to be interesting to see how that pans out under these reforms going forward.
Thank you. Looks like we have one more question here. Maybe you guys touched on this and I glazed over it, but I got a lot of questions between what the difference is between PIP and I'm guessing unlimited medical. Might be something to discuss. Great job.
I'll just quickly, because I do this so much that I can quickly, I think, summarize this. So PIP is your coverage, your no-fault benefits in the event you're hurt. Underinsured and uninsured motorist coverage is coverage you're buying for yourself in the event that you were hurt in an accident where there's an at-fault driver who doesn't have insurance, that'd be uninsured, or underinsured, doesn't have enough insurance. So whatever damages you would be pursuing from that at-fault driver, you are then buying coverage with your own insurance company for them to step into the shoes of the at-fault party and pay as if they were the at-fault party. So the way to look at it is you buy your no-fault insurance and you buy the levels of coverage that you think work for you, or I'm suggesting lifetime, that's what Chaz is suggesting. Whatever you buy, you then have these rights, kind of dependent about what you buy, to pursue against the at-fault driver. But if that driver doesn't have insurance, you're between a rock and a hard place. You're going to be squeezing blood from a turnip. And so uninsured, underinsured coverage is the source of the recovery, and it's through your own insurer.
Yeah, and just to give a real life example, one that I give all the time is that, a drunk driver hits you this morning, you break your neck, you can't work anymore. Like Steve mentioned, you can be sued for debt disfigurement, loss of bodily function, loss of wages. And, they decide a judgment or settlement you get in the total of like $1.5 million. Well, they work at, an office, get paid $12 an hour, have prospects of making more. You're only allocated, you can only go after their assets and future income of up to 25% of their income to age 65. Well, that's what Steve's referring to as squeezing that out of a turnip. So you're going to get, the $8 check a month towards your $1.5 million settlement, but odds are that you won't be able to afford to live on that. And your family will have to change drastically on how they live moving forward because of that difference.
And there's this randomness when I meet people who've just been injured and they ask me, what can they recover? And I say, well, I need to do some investigation to see what type of insurance coverage the person who caused this crash has. And sometimes they have no insurance. Sometimes they have $20,000 of liability insurance. Sometimes they have $1 million. It's all random. But the one way you have certainty over that, at least in terms of giving yourself a minimum, is buying uninsured, underinsured coverage. if that person has their deck sheet and at that meeting, and I'm able to see that they have uninsured or underinsured coverage, I'm able to say to them, well, we're still going to do an investigation about what the other driver had for insurance, but in the event that driver doesn't have insurance, you have, you know, at least $500,000 of uninsured or underinsured coverage. That means that that's the minimum amount of money that you could actually recover if your damage is warranted. So it's protection. It's protection for you and your family. There are a lot of uninsured or underinsured drivers out there. Hopefully there'll be less under these reforms, but the numbers will still be high. It's the best way to protect yourself.
Yeah, well, great. Well, I do want to thank all of our panelists today for your time and all the attendees for joining us this morning. Especially thank you, Grant, for his great work on the PowerPoint. For those, we have 2 more webinars that the Chamber is going to be hosting. We have one tomorrow, a Tech Talk with AT&T. And on Thursday, we have Raymond who will go through the Paycheck Protection Forgiveness. You can find all those on the lansingchamber.org, our website. And again, thank you to our panelists, and thank you for joining us this morning, and we'll be in touch.
Thanks,
Thank you.
Steve. Thanks, everybody.
Thank you.
Are we still recording here? I think we are.
I think we are.
Okay. Maybe we should just sign off then.